their instruction on Vinnie's mental retardation. Resolve that. Our proposal would be simple, that there has been a determination that Vinnie Brown suffers from intellectual disabilities, also known as mental retardation. There's also been a determination that he's competent to stand trial. And I remind you that the state has the burden of proving each element of each crime beyond reasonable doubt. And I will instruct you on that later.
All right. For what purpose do you seek the instruction?
You have to give an instruction about the jury has to consider his mental ability, his age, education, and mental capabilities before they can rely on their statements based on the instructions that we had in chambers, not the instructions, but the conference we had in chambers yesterday and the email exchange last night. You know, it's not clear to what degree they intend to rely on Vinnie's statements, but they certainly, it looks like they will be doing that.
All right, and that was one of the questions I was going to ask you this morning, because that's something we did not address last evening, but you are requesting the standard charge on voluntariness of the statement, etc.
Yes, sir, and I realized this morning that wasn't in our packet on request to charge. I know it's in your charge book as one of the standard charges. And I guess when I was putting that together, I wasn't even thinking about it because we had already talked about that at 2 prior hearings.
Correct. I know that in previous hearings, the state indicated that if the defense intended to offer evidence, y'all would, expert evidence, on the issue of the defendant's mild intellectual disability, that y'all did call potentially reply witnesses. What's the state's position on that, just for the record?
Judge, now that it hasn't been put into evidence, I mean, I know Mr. McGuire brought it up in his opening statement, but, you know, certainly we were in a position, if Your Honor felt that it was relevant for the limited purpose of the voluntariness of the statement, that we may put up a reply witness. But now that that's not happening, I'm not so sure why it's even relevant to charge it. First of all, that would be my first argument. If you are going to charge it for the limited purpose of embedded in your instruction on the voluntariness of any statements, we would like that limited to what was put out in the email last week. I think Hallie sent an email out with some language. It said something to the effect of, and I don't have it pulled up in front of me, but that there has been a determination that the defendant suffers or has been diagnosed with some sort of mild intellectual disability. I'm okay with that. I don't know the necessity of putting in the mentally retarded language as far as the jury's concerned. I think that's inflammatory, prejudicial, potentially for the jury. I do think your clerk's, that Hallie's suggestion, if you're inclined to instruct it, which my first position would be that at this point it's not really relevant. And it's commenting on facts that aren't in evidence at this point for this jury to consider guilty or innocent. So obviously our first position would be that it doesn't really need to be instructed on, but if you're going to instruct on it, and at this point, because Mr. McGuire has brought it up in opening statements, I don't most like a limited instruction, a curative instruction to the jury, that what the limited purpose is not for their determination of guilt or innocence. I think that needs to be clear, because if this is just a kind of an attempt to get the jury to nullify or mitigate his criminal responsibility, which obviously that hasn't been an issue in this case, its progeny as far as Mr. Brown's criminal responsibility, we got a problem. So I think however the judge instructs it, it needs to be very clear that this is not to be considered by the jury for the, the overall question of guilt or innocence.
It sounds like we're largely in agreement then.
It does, and I would just say that the reason that I suggested the language about competency, the objection that we have to what was sent around an email last week would be saying, would be introducing that he's criminally responsible, because that would just confuse the jury. That's not an issue in the case, and that would almost be like saying he's guilty, which is for them to decide. So if it's just, there's been a determination, doesn't have to say it was by you, there's been a determination that Benny Brown has intellectual disabilities. The reason we suggest mental retardation be included is so that if they don't know the terminology, it's changed. And we don't mind the limiting instruction that is to be considered in connection with the statements.
Just so it's, and I think I made this clear before, I think it's confusing to the jury, period, that now they're getting instruction on their intellectual disability when they haven't heard any witnesses testify about that. But I can understand Your Honor's position if you're instructing on the voluntariness of the statement. We just want to make the language, and I'd like to look at it and make sure we're on the same page with it being very clear from that this is not to be considered by the jury for any kind of guilt or innocence determination. And I think the language that Allie wrote up last week was sufficient to cover that. And I would ask that it be put into the instruction at the same place where we instruct about voluntariness of defendant's statement.
We would agree with that.
What I'm inclined to instruct the jury on that issue is quote, there's been a determination that the defendant has mild intellectual disability, also known as mild mental retardation. However, the defendant is competent to stand trial. The existence of any intellectual disability is relevant only to the question of the voluntariness of the defendant's statement to law enforcement. And again, it does not affect his ability to stand trial or any culpability. Is that acceptable to everyone?
Yes, sir.
Just maybe to add the word any criminal culpability, Judge, I think that's.
Well, I'll think about that. Maybe I will. Question of jury instructions, I know that the defense did move for a directed verdict on the attempted murder instructions. The court's had an opportunity to reflect on that, and the court will go ahead and the court's previously denied that motion. The defendant stands indicted for all of those attempted murders. The court will over the defendant's objection, instruct the jury on all the attempted murders that the defendant is charged with. I don't know that I have a current copy of the code. Attempted murder is also classified as a violent crime.
argued. I did want to put on the record, in connection with the attempted murder charges involving 4 police officers, the exchange of emails last night regarding the solicitor's request for a lower burden on malice. And the solicitor essentially acknowledged in the emails that one of his theories might be that Benny came out and was shooting randomly, and that he would not be able to prove necessarily the standard of malice that you were charging. Implicit in that was an acknowledgement by the solicitor that there was not a specific intent to kill 4 police officers. And so based on the grounds that we raised yesterday and the additional concession by the solicitor in his email last night, we would renew all the directed verdict motions and add to that motion their statement that they can't prove the specific intent to kill regarding 4 police officers.
Judge, just to be clear, that's not a concession. My position is that, but for the state being able to crawl inside of Benny Brown's head and ascertain his intentions as he approaches his front door with the gun in his hand, and I think the jury can come to either conclusion that he was either specifically aiming at Laura Brown, Peach's aunt, that he talks about her, or he was shooting into the crowd of people where he knew there were law enforcement officers, because he saw that he had time to see the blue ones, and without regard to who he is. And I think that's a reasonable conclusion, even in the absence. So either way, I think the jury can find the facts in either theory under that, based on what we've heard. The police officers all indicate that saw him come out the door to shoot, and he turned in the direction of the crowd that was gathered in front of the bushes to the right of the door within the house. So I don't think that's been disputed. That's the direction, that's where he shot.
So the state does desire the court to instruct the jury or send to the jury all 5 of the attempted murder.
We do.
Very well. The court stated earlier ruling, and with the benefit of the record, Mr. Gross, it may be beneficial if perhaps you were to include just as an identification exhibit at some point in time, print out that email just so that there's somebody they can reference, so they can be referenced in the appellate record if necessary.
I have no problem with that. Will that be a mark of the court?
We'll get that in the record before the end of the day.
If my clerk is still working on the jury charges along those lines, I know that there was a request to charge voluntary manslaughter. I did have a chance to review the brief that was submitted by the state last evening, Stranger's brief, as well as the argument that was made by the defense. I've come to the conclusion that we will not be charging voluntary manslaughter. Every voluntary manslaughter that this case that this court has tried, every instruction that has been given, there has been some evidence indicating sudden heat of passion, sufficient legal provocation, and a simple argument between spouses, even if it concerns questions of adultery, without some indication that the defendant's ability to think rationally, maintain his composure, control his emotions was so affected, so shocked by the incident. Without that evidence, the court will not be instructing the jury on voluntary manslaughter. So that's the court's ruling on that issue. For practical reasons, as I explained in Chambers, there might be practical reasons why that instruction would have been state basically conceded yesterday in chambers that an instruction on self-defense was appropriate. So the court has included an instruction on self-defense. The defendant in this case did also request an instruction on defense of others. Am I correct in that, Mr. Gross?
Yes, sir. That request is in our request number 8 that was submitted and it's been filed with the clerk of court.
All right. What's the state's position on that, just for the record?
Judge, I don't think there's any evidence in the record based on Mr. Brown's statements that he was acting in defense of Ben Juan McGee. That's maybe my inference from some of his statements, but there again, Judge, I'm not gonna fight the defense of others' shoulders.
Well, actually, I was leaning towards not including it. My understanding of the law is that there has to be some perception on the part of the defendants of evidence that he perceived the threat to the other individual, that there has to be some indication that he was aware of the threat. He stands in the shoes of the defendant, or of the person rather threatened. The defendant stands in the shoes of the individual who is threatened. And I'm wondering where there's any evidence that would support that charge. Could someone help me with that, please?
Judge, I would say, I have a feeling Mr. Gross would say this too, and my only concern is we don't charge it. There is some evidence, I guess, if you believe they're witnesses, and some from Rico Kingsborough himself, or the witnesses of Eddie Brown family members, that they're yelling into the window at him and threatening him, and then saying that if he can overhear them outside, saying that, well, I'm going to, Rico and Chris, if he hears them outside, he's going to assault one of the family members. I mean, I know it's a stretch, Judge. My only concern is if you don't charge it under, as we pointed out in discussions. But I agree. I think that perception needs to come from the defendant. And the statements that have been admitted that he gave to law enforcement afterwards, it seemed pretty clear that he was just trying to kill a female in-law, not the ones that were making the threats, allegedly making the threats.
Very well. If the state is willing to concede that charge is appropriate, I will include it. The solicitor also requested last evening a Zahn charge, M-O-U-Z-O-N, malice charge, which is essentially synonymous with kind of a reckless frame of mind. I indicated to my clerk last evening that my intention was to, so that I'm not just simply repeating the malice instruction twice of the assault, or not the attempted murder charge and the murder charge, so that I'm not repeating myself. I'm going to separate malice out, put it in a different portion of the instruction, and I indicated that I would include the snippet from the Zahn in that instruction. That's what I said to her. I assume the defense does object to that, correct?
Yes, sir. And we actually don't see the Malzahn charge as being a malice charge. We see that being more of a general intent charge. For murder, you have to have a general intent to kill, not a specific intent, and malice. So including a general intent in the malice charge, I think lowers their burden of proof. It's not what they represent it to be, and it's going to confuse the jury. In the preamble to our request to charge, we cite to the Worton case out of Orangeburg that I tried, and so I can tell you that the jury instruction that the Supreme Court said should not have been given was actually an instruction that was correct on the law, but was not appropriate to be instructed to the jury in that case. And because it served to confuse, it required reversal, and that would be our position on that.
Solicitor, well, as a preliminary matter, again, we are dealing with two different mens rea, and the murder charge and the attempted murder charge. And I intend to instruct the jury on the attempted murder charge. The specific intent to kill is part of that. Of course, malice is part of that as well. Do you want to respond to what Mr. Gross has put out there, Solicitor?
Well, Judge, I think both could apply in this case as well as the charge, particularly as to two murders. I think as to not confuse the jury, we need to instruct them on what malice is in this state. Malice can be expressed, intent to kill can be implied. And one of the primary ways, if indeed Benny was decided, well, I'm going to kill myself, but I can't follow through with it, and I'm going to go out shooting to this crowd and take out as many people as I can before I go, that's Mouzon malice. And I think that the jury could reasonably conclude that he was acting, I guess, with extreme indifference to the value of human life, that it didn't import will. They could find that. And if they find that, certainly, but they could also find that he was specifically intending to shoot a female family member, and in the process shot and killed Roger Rice and shot in the direction of other officers. It would be specific. So I don't know that necessarily it's inconsistent. I think based on the evidence we've heard, both are applicable. Particularly the fact that he already told his family members, I'm going to kill myself that night. We know he had suicidal ideations that night and was very clear on that. So I think that the suicide by cop theory is very vital based on what we've already heard in testimony.
One moment, please.
Yes, sir.
My clerk has pointed out that in the court's proposed instruction on attempted murder, the court specifically describes intent. Intent means intending a result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which he may naturally and reasonably infer intent. Evidence of the character of the act, the character of the instrument used, the manner in which it was used, the purpose to be accomplished, resulting wounds or injuries may be considered in determining the intent with which the act was committed. Intent may also be inferred when it is demonstrating that it voluntarily and willfully committed an act, the tendency of which is to destroy another's life. I think that really encompasses what you're asking for by way of the Mouzon charge. The Mouzon charge seems to go to the question of intent. I would agree with the state that you could have a generalized malicious intent without intending a specific target. The classic scenario is the drive-by. Somebody sees a large gathering at a club or a business, and they simply drive by, firing randomly in the crowd, not necessarily intending to kill any specific person, but acting in such a reckless or dangerous manner that one would naturally and reasonably assume that someone could be injured or killed. So I think that really goes more to what you're getting at in the request that you're making as far as the malice instruction. So I'm not going to charge that portion of the Mouzon charge. I think it's covered under the intent aspect.
Okay. My intent was to argue that when I'm arguing the law, to I guess the question is, you're going to argue, you're going to charge what you're going to charge. It's applicable law in the state, so I think it's appropriate.
Appreciate your position. I'm sticking with the malice charge, standard malice charge in the bench book, which I'll print these out for each one and let you all look at them again, and I'll give you some additional suggestions, even though we are keeping the jury waiting.
If I could just be heard,
Go ahead, George.
we believe that we would object to that in charge because we believe that's a inference charge that's impermissible under Belcher. Essentially, you change guns, deadly weapons, with instrument, and how it's essentially no different than Belcher.
Appreciate your position on that. I'll be charging intent instruction. I have not instructed per Belcher. I have not instructed that malice can be inferred from the use of the deadly weapon. I do believe that the intent instruction, though, is still good law. That your objections noted. Anything else we need to think about or I need to incorporate?
What are you going to charge on transfer of intent and circumstantial evidence?
I'm going to go with the newer charge on circumstantial evidence, transferred intent. Transferred intent is a defendant with malice and forethought attempts to kill another person, but by mistake injures or kills a different person. The defendant still has the intent to kill. The intent to kill is merely transferred from the original person. The defendant intending to kill the actual person killed or injured. And I'm going to ask my clerk to add language. In short, malice follows the bullet. That's what we discussed in chambers yesterday.
Well, actually, that's not what we discussed in chambers. That's only part of what we discussed in chambers, because transfer of intent also applies to self-defense and defense of others.
Right.
So there needs to be language in the charge that if the person is intending to defend themselves or defending others, that intent is not the intent of the person that's harmed, it's the intent of the person who's being charged.
And I pulled that language when I decided yesterday that I was not going to charge the question of defense of others, but seeing as how the state is now conceding that, clearly I will have to put that back in.
Judge, on that point, I think malice follows the bullet seems to encompass all of this. I'm not sure why
If you can have transferred intent for purposes of establishing malice, solicitor, you've conceded by saying that they're entitled to a defense of others challenge, that a person can be acquitted based upon the fact that they did not intend to shoot the person that got shot. That was my entire point a moment ago, sir.
Well, Judge, I want to make
A classic example is the case out of Richland County where the gentleman was trying to defend his daughter from a group of people who drove by in a car. He fired a shot at the people who were shooting at his daughter. He missed. He struck a child across the street. The child died. That's the classic example.
Well, I don't know that my position before was that I was absolutely conceding that. I just said there was very scant evidence in the record that possibly was supported. I'm trying to protect it as well to not get reverse way. But I really hadn't thought about that point as much until you brought it up. Quite frankly, Judge, I don't think there is evidence that's been presented from the witness stand that Benny Brown was acting in defense of this man. So I would not concede that portion. That's the weeds that we're getting into.
But it still goes with self-defense, guys, and they've already conceded it. I don't know why they haven't thought through some of these issues before now. This is putting us in a terribly hard predicament to know what even to respond to.
Well, Solicitor, I will be instructing those. I'm sure that the state is going to argue a single cohesive theory to the jury. As you have rightly pointed out, as all sides have rightly pointed out, the evidence is susceptible to more than one interpretation. And the jury has to sort that out. So I will give them all the options available under the law based on the evidence, the testimony, the inferences therefrom, from which the jury can properly draw a conclusion. So that's where we are.
Yes, sir.
Just one more question, Your Honor.
Yes, sir.
Just to quickly go back to the voluntary manslaughter charge, of course, we had pointed out in chambers that we think that there's valid case law still existing in our state. This is footnotes 9 and 10 that would provide a basis for the voluntary manslaughter instruction. We just wanted to make sure that that request, which is in request number 6, was on the record and that you would consider that case law.
Very good. When I take a break, I'll take a second look at it. I looked at it last night. I'll look at it again. I'm pretty comfortable with where we are. I'm going to ask my clerk to try and finalize these instructions so we can get them to you in advance of argument. The state's email chain, correct, or the state's objection last night, Mr. Scott's objection to, I know that you had also requested, Mr. Gross, the opportunity to have the state merely reply to what you had put out there. The court is going to follow the current common law procedure for closing arguments subject to your objection, of course. So if you wish to force the state to open up law, they may, you will proceed to introduce evidence and they'll close.
I thought it was resolved last week when we got last argument.
I received an email from him. My implication was, my understanding was that you did in fact introduce some exhibits into the record. The case law says you don't get last argument when you introduce evidence. I think that's where we are.
Of course, we were in a position where we had to pre-mark exhibits, and we would not have pre-marked exhibits. We could have used a lot of their exhibits to prove our case. But also add, they're also putting us in a position, what they talked about in chambers yesterday, what they talked about in emails last night, what they talked about today about suicide by cop is not anything that they've introduced a single shred of evidence about, and it's not a theory that they presented to this jury. We are not going to respond to facts and arguments that they have not made in advance because we don't know if they're going to follow through on that. We can't respond to things that we haven't heard. If they get up there and advance a theory different than what they advanced in their opening, we're going to ask to be able to reply to that. And part of our basis is going to be the same argument as sir reply when something new comes up in reply testimony. Our belief is even under common law, the discretion or the order of the arguments is actually discretion. And if they're going to sandbag us, like they've done in other cases, this is going to be a huge issue on appeal.
Appreciate your position. I don't know what they're going to argue. I don't know what they intend to argue. I will hear you at the conclusion of their argument. And if you hear them pose an objection during it, if there's no evidence to support that argument, then you are certainly at liberty to do so. I don't like it necessarily when attorneys interrupt other attorneys during their closings, but the court will allow an objection along those lines, or any other objection which is appropriate under the rules if they go too far astray. I understand what you're saying, Mr. Gross, and honestly, the reason I required everyone to pre-mark the exhibits was, and the reason I did not think that it was going to be any problem is that up until yesterday, every indication was that the defense intended to offer a defense. There was never any, you had alluded to a physician who was only available today. I never considered that that physician would not be testifying, and obviously if there was a possibility, no matter how remote, that you were not going to present testimony, the time for me to hear that would have been when the court issued the order. You were comfortable with the order. The trip to the scene was on your motion as well.
But that's not evidence. Actually, that's specifically not evidence under case law.
Under case law, a tattoo is evidence. Just standing up and showing the defendant showing a tattoo is evidence. So,
Right, but there's also specific case law that says a crime scene view is not introducing evidence. And that's not the reason I stood, though. The reason I stood is that we stand by our motion to require them to open fully on the law and facts. Therefore, they are required to open on the law. We also, in agreement with your order, 30 minutes to each side. We still think, particularly with the amount of time that we used this morning, that it should be limited to 30 minutes, and both of their arguments should be 30 minutes.
I really feel that that's, if you talk more than 30 minutes, you're losing the jury anyway. I've seen jurors completely zone out after 20 minutes. So if you go longer than 30, I think that you're running into trouble anyway. And this is an intelligent jury. If the argument cannot be made in 30 minutes, then there's a problem.
I just don't want them to get up in their rebuttal argument and drone on and on for hours. I just want it very clear. They get 30 minutes.
I don't think I've ever gone longer than probably 35 to 40 minutes, and closing it my longest. So
Very good. And there shall be no problem keeping it to 30 minutes per paragraph 6 of the court's order that I issued back on June the 2nd governing this trial. So total of 30 minutes if you intend to open on the law.
Well, we're requiring that they open on the law.
Very good.
we have no problem with that.
We will, I know that I'm keeping the jury waiting, but we're going to finalize these instructions, get you guys a copy so that you can object. And that way, hopefully, we can seamlessly go from the defendant resting into argument